The guy that stole the car was a 5-time felon, had previously been involved with a car theft, had been suspected of a prior car theft at Avis. So he testified in the second trial that getting hired at Avis was like hiring a child molester at a daycare center.
Oh, man.
Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are Robin Fraser Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and currently serve on the Board of Directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with us here today is our spectacular co-host, Lester Tate. Lester?
Hey, Robin, how are you this morning? And
I'm doing
and
fine.
A belated happy birthday. We should call this Robin's birthday podcast.
Thank you. I got a lot of very, very nice messages and text and social media reaching out and just makes your birthday bearable.
I started to say that our birthdays were a scant 2 weeks apart, but that would not do you justice because mine was a couple of years, I think, or more before yours. So
yeah, but who's counting?
That's right.
Well, today we are going to be talking mainly about premises liability cases, but really about a variety of cases, kind of large in litigation, very serious cases. Now, our guest is the guy who wrote the book on premises liability, but he's also involved in a lot of other cutting edge litigation that we're going to talk about. And our guest is a trial lawyer, Mike Neff. We are excited to have Mike join us today. Let me tell you a little bit more about Mike. Mike Neff is the owner and founder of the law firm Neff Injury Law here in Atlanta. Neff Injury Law handles premises cases, trucking cases, products liability, automobile cases, and nursing home cases. He is the author of the book Premises Liability, A Guide to Success, and has written a second book, Advanced Premises Liability, A Guide Through Trial, published by Trial Guides. From 2011 to 2017, Mike has been lead counsel in trials in which juries have returned verdicts of more than $100 million totaled. One of those verdicts was in the Martin v. Six Flags case, in which the jury awarded the plaintiff a verdict of $35 million, which we're going to talk about. He was also lead counsel in back-to-back trials against Avis Rent-A-Car, in which the jury returned verdicts totaling $54 million. Those have unfortunately been reversed by the Georgia Supreme Court, and we're going to talk about that and the impact that appeals have on cases. And we're going to talk about some cutting-edge cases that Mike has brought against Snapchat that look promising. Mike is an active participant in the American Association for Justice and serves on the executive committee for AAJ's Traumatic Brain Injury Litigation Group and Inadequate Security Litigation Group. In 2014, he served as the chair of AAJ's Complex Regional Pain Syndrome Litigation Group. Mike earned his law degree from the Pennsylvania State University Dickinson School of Law in 1993. You can learn more about Mike on his website, Neff, that's Neff, injurylaw.com, neffinjurylaw.com. Mike, welcome to the show.
Thanks so much for the invite.
Good morning, Mike. And it's okay to talk about the Nittany Lions, too. You may be excited about them as well this fall as a Penn State grad.
Well, I actually went to college at George Washington, and we did not have a football team. So I have to, I guess, take my associations where I can get them. And Penn State is definitely a big deal up north, for sure.
Have you adopted the Georgia Bulldogs?
Yes, and the Yellow Jackets. I went to a city school, so I have some affection for the folks on the flats, just because I kind of grew up in a bigger city, so to speak, in DC.
That forever endears you to my heart as a Yellow Jacket alum, Mike. You just don't know the warmth that spreads over me hearing that we have sidewalk alumni as well.
Yeah, those Tech fans are few and far between, so we really rejoice when we get one.
Well, yeah, it's a little tougher rooting for the Jackets, but I like the underdogs.
Me too. Don't we all? I mean, as plaintiff's attorneys, isn't that kind of why we do what we do? We like the underdog.
Pretty much.
Mike, let's start the show by having you tell our listeners a little bit about your career. We know where you went to law school. Why did you go to law school? Why did you become a lawyer? And tell us just a little bit about why you decided to become a lawyer and what your practice is like.
Yeah, well, that's kind of a circuitous path in a sense, but in a sense, maybe predestined. My middle name is Lawson, Lawson, because I am the son of two lawyers. And so I grew up at the dinner table hearing about the practice of law in central New Jersey. And some days after school, was stuck in the conference room doing homework while things were happening in this middle New Jersey law practice. And then I went to law school and then I went to college and thought I wanted to be a stockbroker. And then Black Monday rolled around and I thought, maybe I don't want to be a stockbroker anymore. Maybe I want to get into something where I can control what happens. And that was a naive thought. But that kind of turned me to law school. And so I went to law school initially thinking I would do real estate law or real estate development. And by the second week, I was getting called by the torts professor to argue for the plaintiffs in almost every case because kind of subconsciously, I had been answering the first 2 weeks always for the plaintiff. And I think that rooting for the underdog kind of was, ingrained in me. And without really knowing that was the plan, all of a sudden I wanted to be a trial lawyer, and all of a sudden I'm on moot court teams. So even though I've got a couple semesters of tax and real estate finance from law school on my transcript, I didn't really use those.
So what kind of law did your parents practice? What kind of stories did you hear around the dinner table growing up?
Right. Well, my father did a lot of real estate law, zoning, and that's where the development exposure kind of came in. And my mom did a lot of family law. So it was not heavy personal injury exposure as a kid. It was more, I guess, nuts and bolts of helping people out.
Did they practice together or were they in separate firms?
No, they were Neff and Neff as they were practicing.
Well, my kids have grown up with the same sort of background as you, Mike, where you talk about cases around the dinner table. And I can remember when they were in high school, their friends would say, do y'all really sit around and talk about like that in politics? And I said, yeah, we really do. At the dinner table, we talk about politics and law.
The family business.
To see, if they turn out like you, Mike, I'll be very happy. I'm glad to see you can have a normal upbringing that way.
Yeah. Well, I'm sure your kids are doing good stuff. I know your son's been doing good stuff in the art world, and your daughter's following in your shoes.
Yeah, that's right.
Yeah. That's great.
Has your practice always been plaintiff's personal injury?
Not always. I started my practice in 1996, and I basically was taking front door law cases, whatever came in the front door. And what was really interesting was around that time, Michael Crichton had written a book, Disclosure, which they made into a pretty bad movie. But employment discrimination was on a lot of people's minds. And I took a fair number of employment cases my first 3, 4, 5, 6 years in practice. And those are hard cases, I learned. but they taught me how to litigate in federal court, and they taught me how to litigate against bigger firms. And I was better for having taken them.
So how did you end up in the great state of Georgia? You're from New Jersey, went to school in D.C., then at College Station. What brought you to the Peach State?
Well, it's kind of funny. My family is predominantly from New York City, but two of the Leotas, which is my mom's side of the family, navigated their way down south. One taught at Georgia Tech, and one taught at Emory. And so there was a connection, at least distantly. And then when I got to law school, my professor was from Atlanta and said really good things. And the Olympics were coming. And the clincher was after law school, I visited a college buddy and came down to visit him in February. And we went to the pool, and there were a lot of young people hanging out by the pool. And I thought I could dig out of snowstorms up in New Jersey in February, or I could come down to Atlanta and hang out at the pool. And the pool had a very motivating influence on me.
The pool won.
None of those were Georgia Tech students, though, because they were all off studying someplace. I'm sure,
Yes.
They
may have been Emory students.
That's great. And as a native Georgian, I think I'm the only native Georgian between the three of us. I always love to hear the stories about how other people, come here and that other people do love our state.
Well, it was crazy. I was the president of the Atlanta JCs in 1996, and I would walk into a meeting or a mixer and ask new people where they're from, and 90% of them were from somewhere else. So it was an easy icebreaker.
Cool. Well, now I would say you are known as a plaintiff's trial lawyer. You take obviously what I would call very significant, serious or catastrophic injury cases or death cases, and you trial. And we want to talk about some of your trials, but and I mean, we're going to talk specifically about some of your trials. Before we do that, can you talk to us a little bit about your process of getting ready for a trial?
Right. Well, getting ready for a trial starts when you get the case to me, because I think we have a commitment in the firm that if we take the case, we have to try it. We have to be prepared to try it. And not every case goes to trial, but I think if you don't prepare cases for trial, you get behind the eight ball. So I'm thinking about trial, when it comes in. I'm thinking about trial during depositions, thinking about trial when we're dealing with summary judgment. So it is a years long process, particularly for the bigger cases. So it is not I pull out the file a month before and write the opening statement. For me, it is, kind of a longer process where I'm tweaking things as I go along.
Yeah.
So a lot of the cases that you're handling, though, like premises liability cases, and just for our listeners, particularly listeners who aren't personal injury lawyers and aren't even lawyers. I hope we have a good bit of those that listen. A premises liability case, and there's certainly all different kinds now, negligent security, all types of things. But, traditionally, the most common kind, I guess, is a slip and fall case. And I've often joked that, if you sent me to a psychiatrist that plays word association games, what pops into your mind when I say they slip and fall? I say summary judgment, because that's the one hurdle that you have to overcome. And my impression, at least the cases I've handled, it's not any less of an issue in non-slip and fall premises liability cases than it is in premises liability cases. And I remember being at Georgia Tech, where I took the first law class I ever took, and the professor, telling us we did a case where, you didn't get a jury trial on it. I thought you got a jury trial on everything, before I went to law school. So what's sort of drawn you toward these cases that you really have a very substantial intellectual and factual challenge to get over summary judgment and to get the case to trial, and how do you plot your way through that?
Well, it's crazy sometimes how things come full circle. So I grew up in a real estate kind of environment at home. In fact, my first job as an 18-year-old was as a real estate agent, and I would spend all day looking at vacant property, owner lists, and I'd look to buy non-conforming lots, and then my father would help me get a variance, and then we'd sell them to builders. So it was, I always had this interest in real estate going back to being a teenager, and thought I would do a lot of development. So property rights were a big deal to me. I was a finance major in college and took a number of real estate classes. So there's always been an interest and a passion in that area. And, ironically, I met a woman that is an industrial engineer and managed construction projects, and we got married, and I had this built-in expert that I didn't know about. And, I started asking her questions and was amazed at how much I didn't know. But I started learning, and, it kind of snowballed from there, because when I got out of law school and I opened my practice, a friend of mine said, well, what are you going to do? What type of law? And I said, I'm going to do personal injury. And he laughed and said, well, we're going to call you slip and fall. And I said, oh, no, I'm not going to do those cases. And lo and behold, I wound up doing some of those cases because what I learned eventually was that there are safety rules in place to protect people. And if you follow them, you prevent a lot of people from getting hurt. And if you don't, then people can get seriously injured or killed slipping and falling on a wet floor. I think that's kind of the big psychological hurdle to get people from thinking about a banana peel or an insurance scam to thinking about this was preventable and this person's life is never going to be the same.
When you take a turn down aisle number 3 at the grocery store, you don't think your life's about to change there, but it has for, hundreds and thousands of people, over the years.
And I think in some of the cases you do, Mike, they're you have to build them factually as we do every case, but it seems like they're so intricate and the law is so challenging that you must know going into some of your cases, you're going to have a lot of motion practice, a lot of brief writing. It may go up to an appeals court during the case and back down before you ever get to a jury. Do you think about that? Do you kind of project that out and say, oh, I don't know, there's too many motions in this case, or you just take it on and say, well, we're just going to deal with it as we meet it?
Right. I think it's funny going back to the beginning, the fact that I started out doing a lot of employment law kind of set the bar high. Employment law back then, if you beat summary judgment, they paid you, but most of the time you didn't. The Northern District of Georgia had a 90% summary judgment rate on employment cases. And I'm proud that I never lost a case in full. I lost part of a case, but I was able to get through that. And so it didn't really faze me after doing that for a while. It just, okay.
You can handle it.
It's just part of the road.
Yeah.
I think the Northern District summary judgment rate is about 98% now. It certainly hadn't gone down over the years.
I have a tremendous respect for lawyers that do employment cases because they're hugely important. But, I kind of realized after 5 or 6 years or so that this might not be the area of practice that I'm cut out for.
I think of you as a trial lawyer. You try a lot of cases. Do you also mediate cases?
Yes, especially when we're ordered to.
Yeah, which often doesn't result in a settlement when it's ordered.
Right.
The parties have both want to resolve the case for it to work, I think.
Yes.
But I just didn't know if you had a inclination not to even suggest mediation.
Yeah, that's not my default. My philosophy generally is the defendant will pay you when they want to pay you, and there's nothing that I can really do to speed that process up besides my job. And the light bulb either goes on and they want to resolve it, or we keep moving forward. So there's no sense, knocking yourself out that, we're going to get this done next week or next month, or it's just a process that you don't have complete control over.
Well, let's talk a little bit about premises liability law. You've talked a little bit about it already, that there are actually safety rules in place so that people can walk across a certain area and not fear getting injured,
Right.
which we call premises liability. I often call it premises safety. You've written 2 books about it, which is remarkable. Who did you write the books for?
Wow. That's another story.
Did you write them for lawyers or for lay people?
Yeah, the books are published by Trial Guides, which is a niche publisher on the West Coast that provides educational books for trial lawyers, plaintiffs' lawyers.
All right.
So I was motivated by reading a number of their books, like Rules of the Road by Rick Friedman, Polarizing the Case by Rick Friedman. David Ball is now getting published by them. So there were some really great authors that were instrumental in my development as a lawyer. And the story kind of goes back to Snowmageddon. I was having lunch with a young lawyer and lost track of time, and we got kind of stuck at Lenox Mall. It took me about an hour and a half to drive a mile and a half home. And I was lucky because it took some of my friends 9 hours to go 3 miles. But one of the kind of moments I won't forget from that lunch was the lawyer I had lunch with said to me, "Mike, when you were in law school, did you know that you would try a $35 million case?" And it was kind of like in Wayne's World, where they go back in time and everything gets wavy. I kind of was transported back to law school, Mike Neff, and I thought for a couple seconds, and then I said, no, I had no idea that a $35 million verdict existed, or how to get one, or that it was possible. And so that innocent question stuck with me. And a couple months later, I thought, well, maybe I've got some stories to share. And I wrote a proposal to Trial Guides, and they said, yes, we would love for you to write a book geared towards younger lawyers or lawyers that haven't done premises cases. And we want you to write it in a tone like you're having lunch with them, which was easy for me because I have lunch with a lot of lawyers. So that's kind of how it got started. And the book I initially wanted to write was kind of like the director's cut of certain trials where I love reading books where lawyers explain what they were thinking about when they ask certain questions, and there's a lot of transcript things. I find that insightful and kind of helps me get creative. So I kind of wanted to do something like that, but they thought start with the first book, which will be kind of the introduction, and then we'll let you get into trial stuff later. So
your Six Flags, Martin versus Six Flags case, I don't know all the facts, certainly not like somebody who was involved in it, but am I correct? Do I recall correctly that the actual injury to the plaintiff in the Martin versus Six Flags case didn't actually take place on Six Flags premises. Is that correct?
That's fair to say. That was certainly a major point of contention by the defendants, that the beating took place 200 feet away.
And you may want to talk about the facts of the case too. I'm not trying to, jump in the middle of the story, but I just remember that being a feature of that case, a feature or a bug one, I'm not sure which.
Right.
To give the listeners the setting, this is one of your very large verdicts. This is the $35 million verdict, right? And it was against Six Flags, and you represented a young man who had been beaten, I think, at the bus stop. But set the story for us a little bit. Tell us a little bit about the facts of that case.
Sure. And I just want to give some significant credit to Gil Deitch, who worked on the case with me, and then his partner later became Andy Rogers. So Andy, Gil, and I tried it together. I was fortunate to be lead counsel. They had a trial like 2 weeks before, so I said I'll take lead, and they were good with that. So it was a team effort for sure. But Martin versus Six Flags was fascinating because of it was very much an accordion, where you pulled facts out and you compressed them, and there was a major timeline. And when we got the case, we didn't know whether it was going to work or not. And we took 64 depositions, which is a lot.
That's a lot.
More than I've ever gotten close to. I think the next biggest one I've done had 40. So it was tremendous amount of legwork in it. And one of the big issues was that Six Flags had gang graffiti in their locker room for 10 years, their employee locker room. So we thought that was an important fact because it gave notice of a hazard. And that Six Flags, when they found gang graffiti in the park, would immediately paint over it because, they didn't want their customers to see it, but they also acknowledged that, gang graffiti is kind of like marking your turf, and you don't want to let gangs mark your business as their turf. So it got into issues of security. There were off-duty Cobb police officers that had recommended that there be security there 7 days a week, and Six Flags didn't take that advice because they didn't feel it was in the budget. And so you get into a lot of themes about corporate profits versus safety and, security rules. And then you get into a timeline. There had been a prior incident in the park involving the same group that wound up attacking Josh. So they identified Josh while they were still on Six Flags' property. Many of the group were Six Flags employees. So there was a lot of evidence of a long timeline, going back literally years and years and years. So, we got into issues like how big is an approach, and taking control of property that they didn't own, because Six Flags would do landscaping on Cobb County property going up Six Flags Parkway. And, they argued that, this isn't our property, and yet it's called Six Flags Parkway. So, and they're putting up police officers, and they're directing traffic, and they're doing landscaping on property they don't own. So, part of the issue is whether you're an owner of land, and part of it is whether you're an occupier of land. So there's a lot of facts in that case that gave rise to interpreting Georgia law, or applying Georgia law, or building a case theme or case story to kind of convey, that it wasn't, in our eyes, a bright line test that Josh didn't get beaten on your property, so you have a free pass. There were a lot of facts that did occur on Six Flags' property. And I think the jury kind of put all of that together and, wanted to ensure that Josh was taken care of.
I'll say I was fortunate enough to come and see the cross-examination of the CEO of Six Flags. I think Andy Rogers cross-examined her. This is before Zoom. Back when trial lawyers would tell each other you're trying a case in so and so's court. And I came and watched that, and I didn't know it was going to be a $35 million verdict after that, but I knew it was going to be a plaintiff's verdict. I thought the CEO of Six Flags did very poorly, did not hold up well under cross-examination. And now, this is a huge verdict, and it goes up on appeal. Before we get to that story, because it involves something other than premises, I guess. How did it feel when the jury comes back and reads a verdict for the plaintiff in the amount of $35 million? What did that feel like?
Vindication, justice, really uplifting. I had a good friend who is my trial consultant, and she thought we were nuts for having filed that in Cobb County rather than Fulton County. But we felt that a Cobb County juror, despite their reputation for being conservative, would be more appropriate to assess whether Six Flags did the right thing or not. And so I remember smiling and turning around and asking her how she liked Cobb County now. So that was my mental victory lap. But yeah, it was overwhelming emotionally. I mean, I actually asked Andy to finish up the last remarks to the judge because I was wiped out. I got to give the closing close, and I had asked for 30, and I had told them that if they didn't think that was enough, they could give more, and they decided to, which is not very common. So that was kind of a moment where a lot of things flood through your head.
There's a group of people in society. I call them the McDonald's coffee cup crowd. Who's read about the McDonald's coffee cup, and they think that a jury goes out without any proof of damages. You have to prove everything in your case, that there was a duty, there was a breach, and you have to prove what the damages are. So the jury doesn't go out and say, oh yeah, and even to Robin's point that the CEO didn't do very well on the witness stand, they can't just go out and say, we didn't like that CEO, $35 million. So why don't you tell us a little bit about what your damages were and what your proof of damages were that supported that $35 million?
Well, tragically, from my perspective, the proof of damages was not the challenge in that case. Josh had gotten beaten into a coma that lasted about a week. There was a positive MRI and CT scan showing brain bleeds. We had testimony from his treating psychiatrist, his treating physiatrist, the physical medicine and rehab doctor. We had testimony from a life care planner, from an economist, from his friend's mom, from his grandmother. So the damages were there, unfortunately. Sadly, I remember asking one of the doctors whether the Josh Martin that existed on July 3rd still existed. And he said, no. It essentially, that Josh Martin is gone and can never come back. So very powerful, themes of loss of identity. And
I think that's one of the things that folks don't realize is that, and I tell clients and potential clients all the time, what's a quote good case for lawyers, one that's a high value case, is not a good case for the plaintiff, because they've suffered some pretty catastrophic injury. One other
Right.
thing I want to talk to you about, and I did one of the Midtown shooting case, and you ran into some of the same kinds of stuff that you're talking about, because here you've got, I had one wrongdoer. Well, I had one intentional wrongdoer, but here you've got a whole bunch of wrongdoers that contributed to putting Josh Martin in where his life's never going to be the same again. And there are a lot of people who would be on a jury who would say, well, this wasn't Six Flags' fault. This was the fault of these wrongdoers that beat Josh Martin up. Talk a little bit about how you handle that and how you overcome that handicap.
Yeah, well, certainly if as a lawyer you're going to work on negligent security cases, you're going to have to get a handle on the psychological issues involved in suing a property owner, for the actions of a non-party or a criminal party. So there are safety rules. So that's one thing that I go back to. I mean, security has existed as an industry for hundreds of years, if not longer. Kings built castles with moats, and that's primitive, but we know better today. And there's a big difference between suing a Walmart or Six Flags or a large corporation and suing a mom and pop convenience store with one location. So you sue a corporation that's got multiple locations, that's got layers of management, that's got multiple security experts with decades of experience, that has access to surveillance cameras and security guards and things like that, has access to Cobb County police officers. That's a very different level of sophistication than, you or I that, might have a one location business. It's just a night and day difference. So, you go back to what is ordinary care? What is a reasonable action of someone in the same or similar circumstances? And it's a different process. That standard is the same, but it's a different evaluation to look at what Six Flags should have done, to look at what Walmart should do, than it is to look at grandma, up in Rome, Georgia with, a one location store. I mean, it's just very different. So if you follow the security rules, people are safe. If you follow security rules, you're acting with ordinary care. And if you choose not to, then I think liability is obviously an issue that a jury could decide.
And that issue about wrongdoers and a third parties committing crime on the premises of another owner, that had to do with ultimately the appeals in the Martin v. Six Flags case. As I think the Supreme Court went through the Court of Appeals of Georgia and then the Georgia Supreme Court, and then ultimately the Georgia Supreme Court said, well, you don't have to retry it as to apportionment of fault to the criminals. You just have to you keep the number, I guess. You keep the verdict number. You just have to go back and let the jury apportion some degree of fault to the criminal wrongdoers. Is that fair?
Well, yeah, that's very close. So there was a dispute about who should have been on the verdict form and what the consequence of that should have been. And the Supreme Court's decision was, you've already had this week and a half long trial. The amount of damages would not be influenced by this outstanding issue. So, that is an issue of two or three, I can't remember. The dispute over 2 or 3 people.
Mm-hmm.
And so that's how the Supreme Court came down and the case was resolved between the parties.
I was reading the appellate opinions, and that must have been quite a roller coaster, because I believe the Georgia Court of Appeals said you have to go back and retry the whole case. And then it's appealed to the Supreme Court. The Supreme Court says, no, not a complete do-over, just a portion, which, as you say, then resolved. The other thing that was startling to me, and I think our listeners need to understand the length and breadth of this kind of litigation. The incident to Josh happened in 2007, and you didn't get the final opinion from the Supreme Court of Georgia until 2017, 10 years since he was first injured. That is a long haul, but it may be more average for your cases.
Fortunately, no, but they do tend, especially significant cases, tend to trend 3, 4, 5, 6, 7, 8 years. That one was 10. We had gone up to the Court of Appeals previously, and it was nothing about that case that was easy.
Let's talk about another two more very significant verdicts that you've obtained in the Avis rent-a-car cases. I think one was Johnson v. Avis, and the other one was Smith v. Avis. Right. And as I said in your intro, those two verdicts totaled $54 million. And it was I think they were tried separately, although the two women were injured in the same incident. Can you tell us a little bit about those two cases?
Right. Well, yes, it was two lifelong friends who were minding their own business, sitting on a wall on a summer night, and their lives were forever changed when someone who worked at the downtown Avis on Cortland stole a car and crashed into them. And, one of them lost her leg, one of her legs, and the other one nearly lost her life. They both will never walk the same way, obviously, again. So, it was another situation where we had to fight for, I can't remember if it was 6 years or 8 years. I think it was closer to 8, but that's not something I want to focus on in terms of that part of the process. We do the best that we can do, and things are out of our control at a certain point.
Was the main legal issue in the Avis rent-a-car cases, was that whether, was it a scope of employment that he had committed a criminal? He was an employee of Avis, so he had access to the cars through Avis and through his job, but then goes out and steals a car. Did they talk about that being the approximate cause, or was it scope of employment issue, or what was the main legal? And I know y'all had a lot of battles in that case.
Right. Well, ultimately, the Supreme Court decided that it wasn't foreseeable what happened legally, and so there could not be proximate cause. So there were certainly a lot of legal arguments before we got there. The guy that stole the car was a 5-time felon, had previously been involved with a car theft, had been suspected of a prior car theft at Avis. So he testified in the second trial that getting hired at Avis was like hiring a child molester at a daycare center.
Oh, man.
And Avis's expert from the first trial said hiring Byron Perry was a 0 out of 10 decision. So, we did everything that we could do as trial lawyers, and
sure.
And then, the process continues, and,
there's a sort of disturbing trend that I see, and I'm wondering if it's just me or if you Robin may want to chime in too. But when we talked earlier, I was telling you about when I was at Georgia Tech and I first learned, you don't necessarily get a jury trial. You can get summary judgment against you. That's usually where there's no dispute as to the facts. That's just a ruling as a matter of law. I tell clients all the time, you want to sue somebody for sticking their tongue out at you, you're not going to win. That's not a violation of the law, civil or criminal. But I've been doing this almost 35 years, and there's a stack of cases that I could stack up to the roof here in my study that says questions of diligence, due diligence, cause, proximate cause, and negligence are questions for the jury. And I see so many cases now coming out of particularly the Court of Appeals, but also this one out of the Supreme Court that seem to me to be taking away citizens' Seventh Amendment rights to a trial by jury, to have that determined by a jury. And is that just me?
Well, probably not. If you spoke to some members of GTLA, I think it is, obviously disappointing as a lawyer to lose a case on those grounds, particularly, after a 2-week trial or a 2.5-week trial, after years of fighting and after the trial judge made rulings that there was a lot of evidence. So, I've obviously never been a judge. They have difficult jobs. They have to review the facts dispassionately and apply the law. So, we don't have those restrictions. We're advocates, and, we can be passionate about things and, be happy when we win and be disappointed when we lose.
Well, I sort of have a rule. I don't say anything bad about judges that I wouldn't say in a dissent. Some of the nastiest things that get said about judges are U.S. Supreme Court and some state Supreme Court dissents. And so my difference there is on the law. I just think it's flat wrong given the body of jurisprudence on proximate cause. Well,
I appreciate that. Unfortunately, you didn't get a vote on that case.
You'll still need $5, with my opinion, to get a cup of coffee at Starbucks.
Well, so when I reread the Georgia Supreme Court opinion about proximate cause, I thought, just like you, Mike, you had so much factual evidence to at least make it a jury question about whether that was causation there. I mean, all the things you said about Avis, and they knew all this, and still let him have access to the car keys and the cars. I thought you had done a masterful job building up the evidence to say, okay, now let a jury decide proximate cause. It reminded me the other day when I was rereading the opinion of a suicide case where a little girl, Maya versus City of Richmond, Carl Varnado had the case, went up to Supreme Court. Little girl committed suicide after a police officer from the City of Richmond went around and showed pictures of her trying to kill herself in another incident. And lo and behold, guess what? When all of her friends see those pictures that a police officer had shown to everyone, she was unfortunately successful in killing herself. And they held there was not enough evidence of proximate cause there. The Supreme Court of Georgia held that. And so that made me think of the Maya case when I reread your Avis Rent-A-Car case. So we don't know what to tell you either. We were with you on that one, Mike.
The important thing, though, I think to remember about that is that your constitutional right, as established at the time of the Constitution, was proximate cause was something that was decided by a jury, not decided by a court substituting their judgment, for the jury. Right. And I think that's important for us, the Georgia Civil Justice Foundation, because, one of the things that we talk about is the importance of the right to trial by jury.
Yeah.
Well, I agree with that for sure, no doubt.
Well, let's move on to another case, another verdict of yours, and then we want to talk a little bit about Snapchat before we close, which has not, I guess, hasn't reached a verdict yet, but Let's talk about Veasley versus Monotronics. Another, I guess you would call that premises liability, right? A rape in an apartment complex. Your client was raped by a person.
Actually, her home.
In her home. Okay, her
Right.
home, not an apartment complex.
Right. We sued the security company
because her alarm did not function correctly. Is that what it's like?
Unfortunately, the alarm mechanically functioned fine, but there was repeated system errors in the human beings who had to act once the alarms came in. And it was, a timeline of errors. In fact, when we got into litigation, we found that the alarm company had a policy to put alarms on hold so they wouldn't have to repeatedly call, because they had a rule that if the alarm goes off, you have to call the client and, advise them of the alarm going off. And they would put the alarm on hold for an hour. Well, the alarm went off at least 8 times that we know of before our client came home. And so there was a lot of opportunity, in our view, to warn her, don't go in the house.
Which is why you have an alarm in the first place, right?
Right. Yeah.
Supposedly.
Right. Yeah. So that was a kind of a policy and procedure case where they, are selling security or safety, and then they're just kind of whipping forms to get through them, and that's not their number one requirement or desire. So that was a really overwhelming case emotionally to handle, and it was obviously gratifying to get an excellent verdict.
That verdict was $8,640,000.
That was the judgment.
That was the judgment. It was actually a little bit more, and they said the plaintiff may have been a little contributorily negligent. Is that right?
Yeah. I asked for $8,888,888.88, and the jury decided to give $9 million instead. They rounded up, or they decided to give more, and they held that she was 4% comparatively at fault. I'm not really sure why. We could get into that, but the overwhelming memory of that case, and you asked me about justice.
Mm-hmm.
So this is the case for me that signified justice, and still does. After that case was over, we tried it 10 years ago, November 11th. So it was November 11th of 2011. So it'll be 10 years in about 6 weeks. And it was a week-long trial. Friday was Veterans Day. So the courthouse was closed except for us. We were the only trial there. And it was a holiday weekend, and people obviously wanted to go home, but they did not render a verdict until about 6 o'clock that night. And when they announced the verdict, we're standing at counsel table, and the 13 of them did not leave through the jury room. Instead, they all walked out single file, stopped at our table, hugged my client, each of them one at a time, hugged her, gave her some private words of encouragement one at a time, and walked out the middle of the courtroom, the exit that everyone sees and enters from. So I had never seen anything like it before or since, but that was life affirming to her. She later got the GTLA Guardian of Justice Award, And she got a standing ovation from the lawyers that were present when it was awarded. And she said that the verdict gave her self-respect back.
Wow, that's pretty neat.
Yeah. I mean,
what a moment.
That verdict did things that doctors couldn't do, that lawyers couldn't do. It changed her life. And I think it changed the lives of people that were on the jury.
I was just going to say, I bet the jurors will never forget her or that case either.
Yeah, and then another similar, but not quite as powerful story. After the Martin verdict came in, one of the jurors asked if she could hug me because she appreciated how hard we fought for Josh. So, that there are people out there that care. You don't hear about it or see it every day, but you can occasionally see where we can tap into a communal vibe and people will take a stand for what they believe in.
That's an awesome moment. I love that story. I am curious how you came up with the number $8,888,088.88.
I want to guess that the 8 times the alarm went off.
Yeah, that's part of it. That is part of it. There was a theme of 8s. I never got to explain it to the jury because I ran out of time in closing close. So I just gave them the number after, setting it up. There were 8 alarms. She was held captive for 8 hours, almost 9. So there were just 8s in my head. And unfortunately, there was, objective evidence of harm. I mean, she had PTSD at the highest levels, and there was some gut-wrenching testimony about how profound it was. That was very believable under the circumstances. So but there were 8s in my head, and the jury respected that, I guess.
Now, that case also was appealed. The verdict was appealed. On the issue, I was just reading the opinion yesterday. It looked like on the issue of a limitation of liability clause in the contract when she bought or signed up with the alarm company, and the defense actually tried to limit their exposure to $250,
right?
Based on a limitation of life. But it looked like you kind of handedly took care of their defense of limitation of liability. Court wasn't having any of it.
My friend Mike Terry was appellate counsel on that case, so he deserves the credit for shepherding it after the verdict. So that was one of the issues. There were other issues, but yeah, one of the powerful moments from oral argument in the Court of Appeals was the appellant's lawyer arguing that it was prominent and then having to take out their reading glasses to read the fine print on the back of the contract. So I think that undercut her argument about prominence a little bit.
That's a good story too. I like that. Well, what a great moment. That's a great trial story, Mike. I'm happy for your client. I hope she's doing better. Let's talk finally about the Snapchat litigation that you've got going on. I'm aware of Maynard v. Snapchat.
Right.
You may have some other Snapchat cases in the country. Maynard is here in Georgia. And I know it's already been up an appeal one time on a communications decent Decency Act or something like that. But anyway, let's talk about Snapchat, which is an app that folks use on their iPhones. Tell us a little bit about what Snapchat does and why you sued them.
As all our teenage listeners just laugh that you explained Snapchat,
Yeah,
Robin. That's
my
we're showing
daughter
our
uses
age
it.
here. Yeah, we're showing our age here.
It's on Android phones too. Yes.
Oh, okay. All right.
It's a huge company. It was started by some Stanford College students. It came to prominence because the messages were disappearing, and presumably people were using it for sexting. I do not know anything about that. It's not part of our case. But troubling, to sum up, probably 85-90% of Snapchat's users are between 13 and 25. And so you're dealing, obviously, with a lot of young people whose brains are not fully developed, who don't have great discretion, great maturity, or great judgment through no fault of their own. And what they decided to do, in whatever reasons they have, but I understand eyeballs equal advertisers equals dollars. They decided to publish or put out an application that people could track their speed. So what happened was that there were reports of people posting themselves driving at 100 miles an hour or more. And this predictably leads to some bad results. You have inexperienced young drivers, sometimes driving late at night, going very fast. And people got hurt. And one of the people that got hurt was Wentworth Maynard, my client. Before he got hurt, there was a petition on the internet asking Snapchat to take the speed filter down. That didn't happen. Wentworth got hit in a rear end collision and suffered brain damage. A couple years later, in Wisconsin, 3 teenagers were driving at an inappropriate speed and crashed, and they all died. So we have a case involving the 2 passengers in district court in California. And we have a case for Wentworth and his wife pending in front of the Georgia Supreme Court. I think the argument's the 21st of October. So we're about 3 weeks away from oral argument.
Great.
Naveen Ramachandrappa has done an amazing job on the appeals. We have not been in a position to do discovery because the courts are really struggling with how to apply the law to this, quote, new technology. However, as Judge McFadden had pointed out in his dissent in a 2-1 decision, this is a defective design products liability case, which has nothing to do with technology. The law is old. So we are hopeful that the Georgia Supreme Court will see it that way. And, we're trying to get our days in court on behalf of both sets of clients.
So that case against Snapchat would be, you're talking about defective design of the app. Is that correct? So it's more like a products liability case?
Yes. Mm-hmm.
And I've got the opinion here where the presiding Judge Doyle, who wrote the opinion, held the manufacturer of Snapchat did not owe the driver a duty to alter product design to prevent injuries from a third party's misuse of the speed filter feature. But then, as you said in Judge McFadden's dissent, he writes, I respectfully dissent. At this time, it cannot be said that the allegations of the complaint disclosed with certainty that the Mainers would not be entitled to relief under any state of provable facts. The novelty of the technology and the circumstances at issue should not distract us. There is nothing novel about the legal question before us. The Maynard's allegations fall squarely within the requirements for stating a claim for defective design implicating risk utility analysis.
Right.
So very, very interesting case. I call it cutting edge. I know there have been some other cases against apps, against manufacturers or designers of apps. But to me, I think about foreseeable. Was it foreseeable that someone would use this speed filter, which is designed to do exactly what these young people were doing with it? Speed. Let's see how fast we can go and then show off our buddies on Snapchat.
Right. Yeah.
That seems very foreseeable.
There are a lot of psychological issues that we have not been able to get into with regard to the adolescent brain and its ability or inability to assess risk, and the propriety, the risk utility of putting this into their hands with the possibility of getting social recognition for being an outlier. I mean, it just seems pretty straightforward to me, but of course my opinion is what it is, and I'm representing people.
Seems pretty straightforward to me also. It seems very foreseeable that they would use this in exactly the manner in which they did, and that would exactly injure somebody in the manner it did. So and you said that oral argument in the Supreme Court is what day?
October 21st.
Okay. So I noticed that GTLA and AAJ had both written amicus briefs on your side of the case. So that's always very helpful when you have other professional associations backing your argument up. And for our listeners, if they want to, I assume, will they show it by Zoom, the oral argument, so they could watch on the Georgia Supreme Court website, which is gasupreme.us. And then
I think they're live streamed, even if they're
that's right.
Not,
they're live
not
streamed.
by Zoom.
That's right. They are live streamed. So our listeners can watch that oral argument and will be in for a treat with that case as well. But we wish you good luck on that, Mike.
Thank you.
So, Mike, tell us a little bit first. We've talked a lot about your successes. It sounded like the Veasley case might have been one of your high moments in your career. But do you have a favorite moment or a highlight that you like? This was it. This was the highlight of my career so far.
Yeah, that moment where the jurors hugged her is a highlight. It's not the biggest verdict, but it was, like a movie scene.
That's exactly what I was going to say. It sounds like something out of a movie. Yeah,
I think as a trial lawyer, growing up, we read books and we see movies and we're inspired, and some of us hope that someday we could be part of something important like that. And that really was a culmination of a lot of years of struggling and fighting and learning and trying to get better and all those types of things.
Do you have any, what we would call personal tenets or beliefs or religious beliefs, anything that you as a person bring into your practice and that kind of informs the way you practice law?
Yeah, I mean, not anything easily quotable. I think I do take cases personally. There's a professional school of thought that, we're just advocates and we could argue both sides if we wanted to or needed to or called upon it. And that isn't it for me. I would not be a good defense lawyer. Even in a focus group, I have not been a good defense lawyer. I've been permanently retired from even being a defense lawyer in a focus group. So, I have, a passion for, fighting for the underdog. And I think, when you look at the legal system, the resources that a company like Snapchat can, throw at a defense are extraordinary. And most people aren't in a position to put up a good fight. And so I think in the right case, we need people to take a stand and fight for things that we care about. And, I think when we get to damages in a catastrophic case or a wrongful death case, you're dealing with universally important issues or, themes that everybody could probably agree on, regardless of whether they're a Democrat or a Republican or what their parents look like.
What would you want the general layperson, as I call them, and I think Lester does too, the average walking around person?
The average juror.
Yeah, the average, our folks, the juror, the average walking around person to know about trial lawyers.
Well, I think that people should try and keep an open mind. There are a lot of movies and books that show shady lawyers, shysters, ambulance chasers, all of these kind of long-held pejorative terms. And yet there are also uplifting movies like To Kill a Mockingbird and A Few Good Men, even The Verdict, where lawyers have to pull their stuff together and do something important. And so I think it's an interesting cultural experience we have in America with lawyers, in that a lot of times they're hated until people need them. And then a lot of times people love their lawyer because they actually see this person cares and works hard and sacrifices and, is trying to do the best that they can. And that's without talking about money or risk or, case expenses or any of that. I think lawyers that are good lead with their hearts and their heads, and, their wallets are behind. There are some that lead with their wallets, but, no industry is perfect. Keep an open mind and look at the evidence in the law. That's all lawyers want or should want.
I think that's one of the great things about having you as a guest today is that I think there's look, over 90%, probably over 95% of civil cases end up settling. And there are a lot of people that think, well, you got a lawyer, they're going to settle your case for you. You even have clients call up, when is my case going to settle, from time to time. And, you're talking about the kind of cases you've worked on, Michael, 10 years laboring in the vineyards, sometimes fruitlessly laboring in the vineyards to do that. And I think that's a side of lawyers that you represent well, and that the public needs to know about.
Well, thank you. I've had a lot of help along the way, had a lot of mentors along the way. And I think that's another thing that most lay people aren't aware of, is that, we don't come out of law school as lawyers. We evolve, and the good ones are ones that are always trying to get better. But it's not an overnight process. It really takes years and years and years after law school to approach good, and it takes years and years and years after to get better than that. So
none of us turtles got up on the fence post by ourselves. So
yeah, that's an expression I heard from Jim Butler that confounded me coming from New Jersey. But I'm getting it now.
Well, Mike,
I thought it was a joke.
You get it now. It's been a treat talking about these cases with you. We ask our guests at the end of the program, every one of our guests, what is their definition of justice? And we've gotten some incredible answers. So I can't wait to hear yours. What is your definition of justice?
Oh, when I was asked that, I kind of just got overwhelmed by the photograph in my mind of the people hugging my client in Monotronic's case. So I think I don't have a pithy expression of what justice is, but I think it happens when people draw a line in the sand and say, what happened is not okay. And I'm going to stand up and say something about that. Last story for today, but you mentioned the cross-examination of Six Flags' CEO. Well, I got to watch that from counsel table because Andy handled it. And there was a female juror smiling at the CEO during her testimony. And it really freaked me out. I'm like, geez, I don't understand. I thought we were doing really well. Why is this woman smiling at the CEO? And I got to find out after the verdict. So when the CEO came out, she faced the jury and flashed this big smile at the jury. And this juror, who wound up being the foreperson, didn't appreciate that. And so she gave the fake smile back throughout the cross-examination. And of course, I had no idea of that until the very end. So I was like sleepless the night before closing argument, wondering, did we lose this person or do other people feel that way? And I think that's kind of indicative of decent people being confronted with evidence and saying, you know what, I'm not going to take this. This isn't right. And that is what makes our country special from a lot of other countries, because people, everyday citizens, don't have the power to stand up to big corporations and tell them that's unacceptable. We're not going to take that. So that's justice to me.
Great answer.
Awesome. Mike, it's been such a pleasure having you on. We greatly appreciate your spending a little bit of your afternoon with us, and good luck on Snapchat, and we'll be listening, and keep doing what you do.
All right. Thanks a lot. Appreciate the invite.
You. Mm-hmm.
Thanks, Mike. Every podcast that we do, we finish up with a news article, a recent news article that Robin and I have seen that relates to the civil justice system that we want to share with our audience. Sometimes Robin and I coordinate ahead to make sure we don't have the same one we made today. We have not rigged the system today, but I'm going to let Robin go first today and give hers.
Okay. Thanks, Lester. Mine is an article that came out yesterday, and it deals with lawyers' ethics. And the title of the article is Lawyers' Unfamiliarity with Facebook Privacy Settings in 2008, Nets Win in Ethics Case. So the New Jersey Supreme Court dismissed an ethics charge against a New Jersey lawyer who was accused of using his paralegal to friend an opposing party, and they dismissed it after concluding the lawyer did not understand Facebook privacy settings. So this goes back to 2008, quite a long time ago. But in a lawsuit, this guy was a defense attorney, and plaintiff is bringing a personal injury lawsuit against this defense attorney client. And the defense attorney asked his paralegal to act like a friend of the plaintiff and friend the plaintiff on Facebook, so that he could get access to what he thought would be incriminating information against the plaintiff. I think there was a video of the plaintiff wrestling, and he thought that video occurred after the incident involving the lawsuit where the plaintiff was injured. And the plaintiff's attorney said, I'm going to file an ethics complaint against you, which he did. And ultimately, the New Jersey Supreme Court came down in favor of the defense lawyer, tossed the ethics charge, but only on the basis that back then, way back in 2008, the defense lawyer didn't know enough about it, didn't understand what a privacy setting was. He thought, he testified in front of the Supreme Court or the ethics investigation, that he thought if you befriended someone on Facebook, whatever they put on Facebook was open to anyone in the world who wanted to see it. He didn't understand. Now, I don't know if that's really true or not, but that's what his testimony was. And Supreme Court said, well, we're going to give you a pass because back in 2008, you probably didn't know that. I think today, 2021, that defense is not going to fly in front of an ethics charge.
You'd get a different result.
You would have a different result now, because I can tell you what I think our Georgia Supreme Court would do with it is they would discipline a lawyer for doing that, behaving like that, doing that. And I'm also a little surprised and shocked that an ethics complaint filed in 2008 was finally decided in 2021, and that lawyer had to go through that, ultimately exonerated, but that long of having an ethics complaint over your head, that's amazing or startling or shocking or whatever you want to say.
Absolutely. Well, you did not steal mine, but I do have an article that is from your home state newspaper, the Louisville Courier Journal in Louisville, Kentucky, Robin's home state. It came out on September the 13th.
It's actually a Commonwealth.
That's right. I forgot about that.
It's my home Commonwealth.
That's right. So it is an article about Justice Amy Coney Barrett, who appeared at a function in Louisville, Kentucky, with a crowd of more than 100. And before I go into this, I want to emphasize that I am not picking on Justice Amy Coney Barrett. I'm picking on a lot of Supreme Court justices, including Stephen Breyer, who had made some similar comments before. They're both recognized as being from different wings of the court. But she began her speech by saying, my goal is to convince you that this court is not comprised of a bunch of partisan hacks, she told the guest at a Sunday celebration of the 30th anniversary of the opening of the McConnell Center at the University of Louisville. She says judicial philosophies are not the same as political parties, she said, noting that she identifies as an originalist and citing fellow Justice Stephen Breyer. And I told you I was going to talk about him a little bit too. There's a similar article about him where he says, instead of my goal is to convince you we're not partisan hacks, he says we're not junior varsity politicians. And there's also been similar statements by Clarence Thomas and other members of the Supreme Court. But she said judicial philosophies are not the same as political parties. She said, noting that she identifies as an originalist, and that Justice Breyer identifies from the main school of thought of pragmatism. I think that the Supreme Court, and there were several polls that came out that show the Supreme Court's approval rating is at an all-time low. We do not have plebiscite, justice by plebiscite. That's the one branch of government where might is not supposed to make right, just because you don't go take an opinion poll to do that. But I'm very concerned about all this talk that goes on about, well, I'm not a political party, this is my judicial philosophy, because the outcome of any case is supposed to be based on what the facts of that case are and what the law is that's in existence at that time, either it be legislatively or it be by prior binding decision of the courts, the higher courts in that particular state or in the federal system. And so I think for a litigant to hear that and say, well, I've got my case down here, but how many pragmatists do we have? What's the school of thought? And I may lose because somebody's got a different school of thought about my case is just absolutely horrifying to me. And I think a big part of that comes from people who are put on the court because they have that judicial philosophy by political parties who adhere to that same political philosophy. And a lot of them have never set foot in a courtroom before in their life or represented real people. And I think there's a real crisis going on here. And I applaud Chief Justice John Roberts, because he was a very skilled advocate in front of the United States Supreme Court prior to the time that he went on the bench. And I think he's really tried to walk the walk instead of talk the talk, which is what appears could be happening with some of the others in the, I'm not a junior varsity politician or a political hack. The last thing I'll say about that is I think any lawyer that has spent a lot of time in a courtroom trying to convince judges and juries of something would never make the argument. Whatever you say this case is not about, whoever's listening to it knows that's exactly what it's about. And that sort of tips the hand. But that's my tirade for today.
Well, it reminds me of a comment that Justice John Few from the South Carolina Supreme Court bench, what Justice Few said at our CBOTA conference last weekend when he was talking, and we asked him a similar question about that. Not exactly the same, but similar. And his point was exactly what you're saying. A judge's job is to take the facts, apply the law, and it comes out the way it comes out. And he mentioned two different opinions that the South Carolina Supreme Court had just recently issued. One came out one way, one came out the other, basically similar facts, but different laws applied to the entities involved in the case. And he said, that's how you do it. It's blind justice. You take the facts, you apply the law, and however it comes out is the way it comes out. You don't have an originalist bent or textualist bent. When I think of originalists, I think, okay, what are they going to do with Snapchat? Because there was no Snapchat in the Constitution.
Right. And I mean, look, I understand what people are talk about when they say they have a judicial philosophy. I mean, we have philosophies of advocacy, about how you can best advance your client's case, what to do about that. I understand that those are supposed to be, and I think this is one of the great things that's lost in this country today. Those are supposed to be descriptive of sort of maybe how you behave over time. Like, he's a really good quarterback, or, he's a lousy linebacker. They're not supposed to be prescriptive of the outcome of that case.
Of each case.
Each case. And I think that's the real problem that we're starting to see. And when you've got Supreme Court justice going around the country saying, I'm not a partisan hack, I'm not a junior varsity politician, it is, in my view, very troubling for our system of justice.
Good point. And speaking of that, the United States Supreme Court comes back on Monday.
First Monday in October.
First Monday in October. They're back.
That's correct. That's correct.
As some folks would say, gird your loins.
That's right. Yeah, it's like they used to say about similar things about the legislature being in session. I've heard that. Right. Heard that too. So, well, this has been a great podcast today.
Great,
Robin.
Great episode. Great to catch up with you, and great job by Mike Neff. And until next time, we will see you in court.
Thank you for listening to See You in Court. Brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robin Fraser Clark and Lester Tate, until our next episode, we'll see you in court.